Hurricane Matthew.
Judge, can I put something on the record, please?
Oh, probably depends on what it is, but of course you know.
I don't think the court will like it, but I'd like to put it on the record anyway.
Go right ahead.
Okay. I'm going to ask for a mistrial.
Yes, sir.
At this point, Judge, it's our position that our ability to fully cross-examine the last witness has been severely deprived and interfered with. What I asked to put into evidence had been identified by this witness as his report. On this case, we found was his report on this case as a public officer. We are bombarded constantly by the district attorney's office with the fact that we have a new evidence code, and the first time we try to use the new evidence code, they're going to jump up and down about it. 24-8-8038 is a new, very specific code section that would authorize and allow us to do exactly what we're attempted to do here, which was to put the report of the police officer into evidence. That code section says that the following shall not be excluded by the hearsay rule, even though the declarant is available as a witness. Part 8, public records and reports. And it goes on down. Part 8B says, matters observed pursuant to duty imposed by laws as to which matters there was a duty to report, which is exactly what a police officer has. Part C says, it makes the distinction here, in civil proceedings and against the state in criminal proceedings, factual findings resulting from an investigation made pursuant to authority granted by law, unless the sources of information or other circumstances indicate a lack of trustworthiness. I think Milich and Carlson have both indicated this is a new rule which would authorize the defense to use reports, use police reports, but the state cannot use police reports against the accused. Do we have the? I'm going to find somewhere in there. I can't find my the original one that I had marked. I had one marked as evidence, so I'm going to have to look for that. But
Well, you can supplement the record
okay.
later.
The problem is, Judge, that this would authorize me to use this not only as impeaching for purposes of impeachment, but as substantive evidence as well, because it is an exception to the hearsay rule. This witness, what the court just heard, came out of the box with stuff that was not in his report, clearly against his report, was totally and completely different. And we had the right, in defending Mr. Harris, to bust him on it and to show the jury exactly what was in his written report. And because of that, it's our position that our right to a thorough and sifting cross-examination has been abridged. So I'm going to ask for a mistrial.
What says the state?
The state says that the defense completely ignored the second phrase in subsection B. However, against the accused in a criminal proceeding, matters observed by police officers and other law enforcement personnel in connection with an investigation, or it specifically excludes that. And then I'll cite to you, Your Honor, United States versus Garces versus United States AG 611 Federal 3rd 1337 11th Circuit 2010. In criminal prosecutions, 803AB does not generally allow for the admission of police reports. Courts have opined that the law enforcement exception in Rule 803-8B is based in part on the presumed unreliability of observations made by law enforcement officials at the scene of a crime or in the course of investigating a crime. It's completely excludable under that. I would further state that if for some unknown reason the courts, and if we had a case that interpreted it differently, the defense has specifically cross-examined him with these statements. They are in the record. He has admitted what was in the report. They are effectively have been admitted to this jury, and they have not been prohibited from doing this whatsoever. If they had chosen to. Yes?
Well, talk to me.
Okay. Your Honor, if they had chosen to and done it a different way, like a prior inconsistent statement, and the witness then said, no, I didn't see that, or didn't say that, it could be introduced properly as a prior inconsistent statement, and extrinsic evidence would be admissible at that point. So, Judge, they effectively introduced it. They could have done it a different way if he had answered differently, and this exception does not allow the police reports under the 11th Circuit and based on the statute here.
I appreciate Mr. Boyne pointing out the part of the statute that I intended to read, which was on Part B, excluding, however, against the accused in a criminal proceeding. Against the accused, which is to say, the state cannot rely on this hearsay exception to get a police report into evidence, but the defense can. It is a new rule, and this is exactly what it is intended for. Exactly what it's intended for. He's reading from Carlson. I don't have the Millich book, but I will bring it on Monday, where Millich says very plainly, this is a game changer, and it absolutely allows the defense to now get police reports into evidence. That's our motion.
And Judge, I don't have any cases here that say that it does. I haven't heard one from the side from the defense yet.
Well, regardless, this is certainly not grounds for mistrial. It is a ruling on evidence to which the defendant takes exception. And there is a remedy for that. It's a remedy at law. It's called appellate review. So I am not granting a mistrial. This is not like a witness saying something that's absolutely so prejudicial that you cannot have a fair trial. It's not that situation. It's not that scenario. And there's no reason that I would consider granting a mistrial in a situation where a defendant takes exception to a court's evidentiary ruling. I've made a ruling. At this point, I'm standing by it. You all have not had adequate time to do research on it, since it's apparently something that the defense feels strongly about. I don't mind revisiting it on Monday and give you all a greater amount of time to do research and look into it. The witness can certainly be brought back if that's what needs to be done.
Yes, ma'am.
So the defendant's motion for mistrial is denied. Defense and state are welcome to bring cases and discuss it and be ready to discuss it first thing Monday morning. Although probably I want to take evidence first thing Monday, so probably at the break or right after lunch, because if the witness is gone, you have to bring him back anyway. So the immediacy of it doesn't exist.
And Judge, we would, if there is case law presented that allows them to do this and there's no controversy about it, the state, if it's presented that way and we have law on that, we'll go ahead and allow it to be admissible. He's already been cross-examined on it. I don't think there's any need to bring the officer back. We'll stipulate to it if we get case law on that point.
That may solve the problem too. But I think the first thing is, what is the proper interpretation of this statute under the new evidence code? It's just been raised. I don't know if there's law on it or not. I'll be interested to see. I'm sure you all will provide what you can find, and we'll talk about it on Monday. If I change my ruling, and if the defense is satisfied with simply admitting the report, that is one possibility. But like I said, the witness can be brought back too if need be. We're doing it with a lot of other people. All right. Is there anything else to be done for the rest of the day by the state?
No, Your Honor.
Is there anything for the defense?
No, ma'am.
Everyone be safe and careful. Wear your masks.